Um, and hello, everybody. It's always nice to be invited to present to Apsco members. As Shazia said, there's another member event going on today at JMW's offices, and we have a established relationship with Apsco. So just a bit about myself. I am a employment associate in the team here at JMW. I am around 5 years qualified, so I trained in the area too, so I've got a decent amount of experience. Myself and the team, we support individuals and employers. It's not evenly split. We do generally support employers more than we do individuals. No 2 days are the same in the employment team, so we advise general day-to-day advisory. We litigate in the employment tribunal. We support businesses or individuals when they're selling the businesses and corporate transactions. But more in particular, the employment team are recruitment sector specialists, which is why we have such a good relationship with Apsco and its members. Some of you may know or have come across my, excuse me, heads of department, Paul Chamberlain and Simon Block. They're quite present at various events and they present at Apsco themselves. And just a quick few points on JMW generally. So we're a reasonably large firm. We've got 405 lawyers, about 20 of those in the employment team, 158 partners, and around, I think, four of those in the employment team. We have offices in London, Liverpool, and Manchester. Manchester is our main one with probably three-quarters of the people there. We are full service, so although I'm talking to you about employment law, we everything you'd expect a law firm to do, we do. So whether that's driving offences, police issues, general dispute resolution. Um, so that's just yeah, about me and the firm. So I'm just going to share my screen. I've got some slides here. Uh, bear with me, sorry. Hopefully you can see that. Shazzy, if you could you give me a thumbs up if you can see that?
Yes, yes, we can see it.
Perfect, thank you. So as you know, and you've joined to hear about new rules on sexual harassment, and that's what I'll be talking to you about today. And before we get into it, it's just helpful to understand the previous position and the current position before we move on to what it's going to look like in the future. So the topic of sexual harassment in the workplace is not a new topic. It's been relevant for many years. Most recently, the Equality Act determines or says what sexual harassment is and what employers can be liable for. So Section 26 of the Equality Act says that sexual harassment occurs where both somebody engages in unwanted conduct of a sexual nature, and that conduct has the purpose or effect of either violating somebody's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for somebody. So it's a two-stage thing, really. It's somebody's unwanted conduct, and then that unwanted conduct having the purpose or effect of what can be summarized as causing offense for somebody. Really typical examples of this would be sexual jokes in the workplace. If they could have, if they could cause offense to somebody, even if they're just in the vicinity of the comments, not necessarily directed at them, but that could be sexual harassment. Or similarly showing inappropriate images or videos in the presence of somebody who is offended by those images or videos. And the important point really is on the purpose or effect of how that is perceived by the individual. The Equality and Human Rights Commission, you'll hear me refer to the EHRC throughout, and that's a reference to the Equality and Human Rights Commission, which is an independent body on obviously equality and human rights. They provide two examples which are a bit more extreme than the examples I gave of sort of common or typical sexual harassment in the workplace. So I'll just read these through just for context. So the first is a male worker alters a pornographic image by pasting an image of his female colleague's face onto it. He then sends it on to their colleagues, causing them to ridicule her. There was no sexual motivation behind this act, but the use of the image is sexual in nature. I think that's quite extreme. I don't think many people would argue that that's um, sexual harassment, but that's the example they give. And the second one is a bit more nuanced because it's just slightly different circumstances. A female worker has a brief sexual relationship with her supervisor. The worker tells her supervisor that she thinks it was a mistake and that she doesn't want to continue a relationship anymore. The next day, the supervisor grabs her bottom and says something along the lines of, "Come on, stop playing hard to get." So, although the relationship was sexual and it was consensual at one point, the female worker wanted it to end, and the supervisor's conduct after she'd made that request, by making the comment and obviously grabbing her, was or is unwanted conduct of a sexual nature. Again, I don't think that's particularly controversial. Most people would say that is sexual harassment. The second bullet point here, the Worker Protection Act 2023. This came into force on the 26th of October 2024. So this is the current position. Uh, this takes prevention of sexual harassment just a bit further. And whilst employers, sorry, can be liable for acts of employees and their sexual harassment, it places an active obligation on employers to take reasonable steps to prevent sexual harassment of their employees in the course of their employment. And just an important piece of context here, when this was originally drafted, the obligation was to take all reasonable steps. And the all is quite an important point. So that was removed by the House of Lords, and the final act, the Work Protection Act, said that it was reasonable steps. And we'll come on to what reasonable steps are shortly, but just bear in mind the all reasonable steps point because we'll just come back to that. Importantly, this obligation to take reasonable steps to prevent sexual harassment does extend to employees. So that would be from one employee to another, but it also extends to acts of third parties as well. And that does cause some difficulty and complexities, which we will discuss. So reasonable steps. Whenever the word reasonable is used in legislation or in contracts, it's great news for lawyers because it's ambiguous and it's objective, and the only real winner is somebody who would have to litigate this. It just causes confusion and as I say, ambiguity. So from October 2024, employers are under a positive duty to take proactive, reasonable steps to prevent sexual harassment of their employees in the course of their employment. So before I talk about the slide, I'll just mention some context to this. So the preventative duty is both anticipatory and ongoing. So the anticipatory part is thinking ahead as to what the risk is and what you could do to prevent that risk. The ongoing part is perhaps you've had a report of sexual harassment, you're revisiting your procedures and you're preventing that from happening again. So it's not a one-time thing, it's an ongoing obligation. The duty only applies to sexual harassment. It doesn't cover harassment related to any other protected characteristic at this point. So that could be disability, or race. It's only sexual harassment at this point. What is considered to be reasonable will depend heavily on various factors such as size and resources of the employer and the sector that they operate in. And to add, the reasonableness of the steps taken is very objective, and it will depend heavily on the facts and circumstances of each case. So just looking at the slide here and how it works through, as I said, what will be considered reasonable is objective, and it'll depend on size and resources, sector, and the working environment, which I'll come on to. So I would say that a larger employer with, say, an established HR or employee relations or people services team are likely to have a higher obligation of what is reasonable. Sector, the sector that the business operates in is important as well. So some businesses will not, eh, so that won't operate with third parties, for example. Retail and hospitality is one that jumps to mind where individuals will come into contact with third parties all the time. So they're going to be particularly important to have policies and procedures for coming into contact with third parties, but also back to the point that it operates between employees as well. Working environment is another point, and this is where effective risk assessments come into place, which I'll mention shortly. Um, Risks present in the workplace, so whether that's between two individual employees, whether it's coming into contact with third parties, the types of third parties that workers may come into contact with. So just using the example of retail and hospitality again, they will come into contact with the public routinely for most of their shifts. So they're always in contact with third parties. A typical example in a recruitment supply chain would be an agency engaging a worker and supplying that to an end client. The third party is going to be the end client's staff and possibly other agency workers. And then the final point is how likely employees are going to come into contact with third parties, which again, I will just mention that shortly. So the EHRC prepared a guide, which is, I guess, a best practice on how to discharge this obligation of taking reasonable steps. And they produced this 8-step guide, which I guess in theory, if you're doing this, you're going to have a strong argument that you've taken reasonable steps. So the first one is developing an effective anti-harassment policy. I would say that this should be a given, really. You should have a clear policy that's regularly updated, which deals with sexual harassment, what that is, and what that looks like in the workplace, that it applies to all staff, that it clearly sets out what conduct is unacceptable, perhaps that it's zero tolerance towards such conduct. And taking it further, there should be mechanisms of how to report inappropriate conduct, and then what is done after that, how is it investigated, and what support is available for those reporting it. So that might be a staff handbook that deals with potential sexual harassment between employees, but also it might refer to third party harassment and the ability to report that to the employer. Engaging with staff. So this is a quite a good point and three. So engaging with staff and having regular one-to-ones, running staff surveys, exit interviews, having an open door policy just creates a dialogue between employees and the business, and it just shows that you're listening to their concerns and you're prepared to address any issues that they raise. And linked to that is assessing and taking steps to reduce the workplace risk. So anything that comes up, you can build into risk assessments that you're carrying out. Um, Conducting the staff surveys is a good way of just understanding it in practice on the ground how employees are effective and affected, sorry, and how any um, concerns that they've got can be addressed. And that again, it should be internal, employee to employee, but it should also any risk assessment should cover third parties that employees could come into contact with during the course of their employment. Reporting, so this is back to the first point I made within the policy. There should be clear steps of how to report conduct concerns, sexual harassment concerns, clear mechanisms and processes in place to escalate those. And linked to that is what we do when a complaint is made. So that's having effective processes for it being allocated to a manager, how they investigate it, who they speak to, what the potential sanctions are. And then obviously if there are findings of sexual harassment, then what the sanctions should be. The sanctions point is quite important. If we're talking about employee to employee, it's quite easy because you're in control of both employees. If somebody is found to have sexually harassed another employee, you can discipline, you can warn, you can dismiss. The complexity perhaps is where you've supplied a worker to an end client and they perhaps have investigated themselves and there's a finding that one of their staff has sexually harassed the agency worker that you supplied. That, excuse me, that sanction perhaps is a bit more difficult. You're not going to be in control of that work because you don't engage them, they're not yours. So that's going to need dialogue between you and the end client. Staff training, again, I think this is a given really. It's the bare minimum. So providing mandatory staff training for in relation to the issue. Again, what is sexual harassment? What do you expect? What are the minimum standards? Um, how to raise a complaint? And linked to that is training for managers on how they handle sexual harassment complaints. It's all good and well having processes in place. The managers need to know those, and perhaps they need to know when they're escalating stuff to HR or people services or employee relations. So, for example, I know in my employment with JMW, I think it's yearly, we'll have a an equality training session, I guess, which covers all of this. There'll be a questionnaire at the end, and it's just raising awareness and training and educating staff. Dealing with third-party harassment, number 7. So this is taking effective measures to help minimize the risk of sexual harassment by third parties. So in a pure employment relationship, that could be contractors coming into the business, the general public. In a recruitment supply chain scenario, as I say, that could be supplying a worker to an end client who's coming into contact with third party um, end client customers, employees, other agency workers. And number 8, monitoring and evaluating actions. So this sort of links back to the ongoing obligation. So monitoring the effectiveness of the steps you've put in place. Has anything come up? Have there been any reports? What are the findings? If there are findings, what do we need to change moving forward? This 8-step guide, as I say, if you're doing this, you're going to be in a good position to argue that you're taking reasonable steps. Sexual harassment of employees by third parties. So there is a big focus on this, and I'll come on to it in a second. So there wasn't this obligation to prevent sexual harassment of employees by third parties previously. And just an interesting stat. So in May 2023, which obviously predates the introduction of this, the Trade Union Congress found that 39% of sexual harassment incidents were carried out by third parties. So that's really high. So we can control to an extent employee behavior. Obviously, you can't just stop somebody from going rogue. The third party point is harder. We'll come on to that. But 39% of sexual harassment incidents carried out by a third party, and 52% of women aged 18 to 34 reported that they had experienced harassment from a third party at work. So those numbers are high, and, and clearly that's why, not necessarily based on that research, but why something needed to be done. I referred there in the first bullet point to the EHRC sexual harassment and harassment at work technical guidance. So I've not linked that in here. It's quite a big document, but you can search that and you can find it online really easily. Um, it's guidance that covers sexual harassment and victimization in employment under the provisions of the Equality Act, and the technical guidance provides just more guidance of the preventative duty and how that extends to sexual harassment by third parties. So just an important point to note at this stage, which I'll move on to. Um, there's no right for an employee or an individual to bring a standalone claim in the employment tribunal for third party harassment. How the claim would materialize is the employer's failure to effectively um, mitigate the chances of them being sexually harassed. But again, I'll come on to that in a second. I'll just pull some key points from the EHRC guidance. And one that really jumps out at me is that the EHRC considers that it's really, really, really important and paramount that every employer does carry out risk assessments to assess the risk of sexual harassment in the workplace, particularly with third parties. And it actually goes as far as saying that an employer is unlikely to be able to comply with its preventative duty unless it carries out a risk assessment. So it's just a best practice guide for employers. It might be worth having a look. I will, I've discussed sort of, or will be discussing the main parts of it in this, but it might be worth just having a read. I've said there in the second bullet point, it's a proportionate obligation. So it it does there is this obligation to prevent sexual harassment, but it's all based on proportionality. So it's not at this stage a no stone unturned position. Just some points on that, which are from the guidance. Um, when considering proportionality and reasonableness, as well as the size and resources of the employer, the EHRC just mentions various other factors that will be taken into consideration. So stuff like the nature of the working environment, the sector, which we already discussed, the general risks in that workplace, the nature of any contact with third parties, the likely effect of taking a particular step and whether alternative step could have been more effective, the time, cost, and potential disruption of taking a particular step weighed against the benefit it could achieve. So clearly, you're not expected to take every single step that you possibly could if it's going to be too costly, or if it wouldn't actually achieve that much in benefit, so long as you could justify that decision. Whether concerns have been raised in relation to sexual harassment before. So if there's been various complaints about sexual harassment already, then clearly processes should be tighter and you should be reacting to those. And it's just crossed my mind. I didn't mention actually, we've got time at the end for a question and answer session. So if you've got any questions on anything I've already said or will say, please just put them in the comment box and we can pick those up later. Um, relevant regulatory standards are always going to be important, so you're complying with those. And whether steps taken appear to have been effective or ineffective. So this is the review point that I mentioned. If you've put steps in place and there's still been an incident of sexual harassment, what's gone wrong? That probably indicates something else needs to be done. And you would be expected to address that. And one that jumps out at me is the EHRC says that a step may be reasonable even if it would not have prevented a particular act of sexual harassment. So that's quite concerning that they'll find, say there's been an example of sexual harassment, they're basically inviting a finding that something else should have been done, even if that something wouldn't have prevented this instance of sexual harassment. Um, it sounds a bit bizarre to me. So I've put here an example in the recruitment sector, an example from paragraph 3.34 of the EHRC guidance. I've just modified that slightly. So I've just changed the paragraph 3.34 slightly and changed it to a recruitment sector um, example. And this is one that I've sort of already briefly discussed. So, and this is just an example of reasonableness and where I think could more be done or could more not be done. So we've got a relatively small agency that engages a female worker, and the agency contracts with a third-party food packaging company. Um, the agency at the outset, pardon me, considers what steps it could take um, to prevent sexual harassment of the female worker. It identifies that the individual could potentially be sexually harassed by the end client's employees, other agency workers. It doesn't think that it's a risk that the worker will be in contact with the public because it's a private factory. So the agency communicates with its clients. It says it needs policies and procedures and protocols in place for preventing sexual harassment. Um, it, 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 it it explains the obligation. It asks the agency to communicate it to its workers, and the end client confirms that it has done that. The agency tells the worker if anything does happen, how to report it, and what happens after the report. Despite doing all of that, the worker is then abused by sexually harassed by male colleagues at work. The question then is the steps that they've taken before reasonable in the circumstances to have prevented that? And did they go far enough? You could make an argument both ways. I think that's quite reasonable. Could they have done more? Could they have um, got specific policies in place with the end client, which is possibly quite onerous? Um, and this is the reasonable steps point that I make. It's very ambiguous. So this is just slightly different, slightly different. So whilst there is an obligation to prevent sexual harassment of employees by third parties, there is also an obligation to prevent sexual harassment of third parties by your employees. So equally, steps should be taken to ensure that employees don't harass any third parties with who they come into contact with during the course of their employment. Um, a harassment claim could be brought against an employer in its capacity as a service provider, as anything done by an employee in the course of their employment. That act is treated as having been done by an employer, regardless of whether the employer knew or approved of that act. So just slightly different, but that just takes it further to prevent employee harassment of third parties. So I did mention this very briefly earlier. So what are the consequences if an employer breaches the duty to prevent sexual harassment? There is no specific liability for sexual harassment by a third party. That's slightly different to harassment of an employee of another employee because that's just normal sexual harassment under Section 26 that I spoke about earlier. Anybody that's familiar with litigating in a tribunal for discrimination may be aware that if there is a finding of discrimination, that compensation can be uplifted by up to 25%. There's a similar provision here where if at the same time the tribunal thinks that an employer has failed in their duty to prevent sexual harassment, the same sort of uplift can be applied to any compensation made to the individual. And the EHRC does retain and does have powers to enforce this obligation. So in theory, they could audit and make recommendations. It's not a sanction as such, but it's just upholding um, these new standards and expectations. And there's no escaping from the Employment Rights Bill. So it sneaks into everything. It's the talk of the town. There's just no getting away from it. Everything we've just spoken about was brought in by a Conservative government, and Labour have brought in the employment, well, not brought in, it's proposed. Where we're up to with the Employment Rights Bill for anybody who's just a bit out of the loop, because it's very easy to just get out of the loop. It's so fast moving. Um, it's been through Parliament and it's expected to receive royal assent in November. It's not going to be law straight away. There is a process after that, and it will be staggered because there's some proposals that are more straightforward to implement. There's some which are harder. So it's going to be staggered between April 2026, October 2026, and then into 2027. So the one that jumps to mind is day one unfair dismissal protection. That's not going to be until 2027. Um, and then by then, the general elections around the corner. So that's another complexity, but that's not for this talk. So the Employment Rights Bill just takes these obligations to prevent sexual harassment even further. And I mentioned at the start how the word all reasonable steps was removed from the initial drafting. The proposal in the Employment Rights Bill is that employers will be required to take all reasonable steps to prevent workplace sexual harassment. Now, reasonable steps is ambiguous. All reasonable steps is even worse. So, a really stereotypical example would be um, an office building, and you've got your employees, and there's builders working up, scaffolders working, and uh, and then a female employee is walking into work, and they get heckled by the scaffolders or the builders, um, and the comments are of a sexual nature, and that could amount to sexual harassment. So all reasonable steps in that situation is that speaking to the main contractor, speaking to every builder individually. How far does it have to go? I wish I could give you an answer. I can't. We don't know how that's going to look, whether all is going to stay in there. It had been rejected by the House of Lords again, but it's been left in. So that just remains to be seen. Um, if that obligation is kept in, which it probably will be, it's likely to be October 2026. Third party harassment liability will be introduced. So, where I said before, um, an individual can't bring a claim against an employer for third party harassment, but they could include the failure to prevent sexual harassment. The Employment Rights Bill proposes to bring in third party harassment liability, and that's likely to extend wider than just sexual harassment, and it will relate to any other protected characteristic. That's probably going to be October 2026. Disclosure of sexual harassment is proposed to be explicitly included under whistleblowing legislation, and that could be as soon as April 2026. Now, I think that's a bit of a red herring. Sexual harassment disclosures could already be protected disclosures under whistleblowing legislation. So that doesn't change that. The position is that it could be a protected disclosure. there's just potentially going to be an amendment to legislation, so disclosure of sexual harassment will be a protected disclosure. And the final bullet point, and this has been an ongoing discussion for quite a while, is that any provisions in a settlement agreement or any agreement for that matter, including confidentiality provisions about discrimination or sexual harassment, will be void. And this was sold as a really positive step and progressive step to raising awareness for acts of discrimination and sexual harassment. We spoke about this at JMW, and we're not actually sure that this is a positive step. So a very valuable protect not protection for a business if obviously if they've done something wrong or an employee has, but settlements are often um, established on confidentiality provisions, and the logic is the employee or the worker is paid something for the detriment they've suffered and the sexual harassment they've suffered, but in turn the business protects itself and its image that everything's confidential and it doesn't get out. If that protection is lost, we just wonder whether more employers will be less inclined to settle claims, meaning that individuals will have to go through the full process. They'll have to go to tribunal. They'll have to win the claim, and there's always litigation risk. Um, it drags matters out. There's more claims in the tribunal. So, yeah, that's not necessarily the killer point that it's proposed to be. And then before any questions, I'll just say in terms of practical steps, all you can really be doing at this stage is being aware of what the changes will be, reviewing policies, reviewing how you engage with your end clients, assessing what more you could be doing to prevent sexual harassment of anybody that you supply, your own employees, um, and just are your risk assessments um, are your risk assessments sound? Do you need to be reviewing those more often? Are your records good? If there's ever a complaint that you've not done enough, can you show that actually you did do enough and you've got good records of that? This will all just put you in a good position to show that you put your mind to it and you're aware you're alert to your obligation and you are taking steps to comply with that. Um, so yeah, that's pretty much it. So if you've got any questions, I can't see the
So
comment, but I can
thank you,
see
Tom.
Jazzy's
We
here.
actually do have quite a few
Okay.
questions for you. So we have one from Jimmy O'Riordan. I hope, apologies if I'm mispronouncing. How often do we need to carry out refresher training for employees?
I I think it's part of the same message that it's very case by case. I guess um if you do have reports of sexual harassment frequently or you think it's high risk, then perhaps that needs to be rolled out 6 monthly. Quarterly probably seems a bit too onerous because I suppose there will be a cost to that. 6 monthly, if it's just refresher training and you've got other processes in place and you're not at high risk and you've not got many active or ongoing reports, then annually is probably going to be okay. I know that at JMW, bearing in mind this is more employee to employee and not third party, it is yearly. Um, so I think that's probably going to be enough in most situations.
Great, thank you, Tom. We have another question, which is in regards to conducting a training session for staff, is it appropriate for our internal training department to deliver this training, or would you recommend an external deliverer to conduct the sessions? We are a 200-person recruitment company.
Yeah, I don't have strong views on that. I mean, if your HR functions are sophisticated and trained themselves, there's absolutely no reason um, why they couldn't deliver the training internally. There's lots of resources out there as well. I mean, a quick Google of the topic will bring up lots of resources. Training can probably be put together internally quite easily. I guess the benefit of external advice is you'll be speaking to an expert who can perhaps give more industry specific training, targeted training to managers or employees. But I guess the main point is as long as the training's being done and the key points are being covered, then it probably doesn't matter who's delivering the training.
Great. Thank you, Tom. And we have a question from Stephen Drew. If you were a small business owner with four staff with limited time and economic resources, what are the most sensible first steps or easy wins to being reasonable and responsible?
Policies and procedures are number one, I would say. So, have you got it doesn't have to be called this, but a discrimination policy, I guess. Do your policies tell staff what sexual harassment is? Does it tell them that it could be between employees and it can be with from third parties? That's what you'll fall back on straight away. Then have you is the training in place? Have the to bolt onto the policies, have they then had exposure to training? And then fundamentally as well is just a recorded risk assessment. So in this case, if it's just a small business with four employees, um, you could be quite comfortable that it's very, very low risk and with some conversation around the topic, um, that you'll be covered. But I would say, yeah, policies and procedures and making employees aware of those policies and procedures is going to be a really good starting point.
Great, thank you. And I think we have the last question, which is from Helen Callahan, what protections are best for umbrella companies, given we are not on site with an employee and have no control over them on site? We have a policy, done risk assessments, and uh, the investigation is normally conducted by the end client.
It's a really, really good question, and this is sort of the complexity that I referred to before. So in a supply chain situation, you're absolutely right. It's an umbrella business supplying a worker or an employee, I should say. When that employee is on the ground working, you're absolutely right. There's no control over what's done. So I think this comes back to then dialogue between the umbrella and the end clients, making sure that you're engaging with end clients who, um, uh, well, not engaging with them, but they have procedures and policies in place themselves. Appreciate you cannot stop a rogue employee or worker at an end client from saying something to somebody. And I don't think that's what's expected either. It's just having the conversations, making sure these businesses uh, acknowledge and understand their obligations. And then on top of that, having processes in place for your employees in the umbrella to report sexual harassment to you. How's that dealt with? As you say, it's probably going to be an investigation by the end client. You're not likely to be involved in that, but you want to see any reports and then assessing what steps are taken after that to support the individual. Um, there is no right answer for that, and that is one of the complexities here, and that's why the all reasonable steps is alarming is not the right word, but it is potentially onerous. I don't think you can do more than having policies and procedures, keeping a dialogue with the end client, making sure reporting procedures are clear. Um, and it is, as I say, it's objective. So as long as you can argue that you've taken reasonable steps, you've got records of that, and you can produce those, you should be in a good position to make a strong argument.
Great, thank you, Tom. I don't feel we have any other questions. So this is your last opportunity. If you've got a question that you're burning to ask Tom, please do pop it in the chat and I will read it out. I'll give you a few seconds to do that. So that's really helpful, Tom. Just going back to a point you made earlier regarding NDAs. So you're saying at the moment it looks like they cannot include the sexual harassment elements within an NDA. and potentially also a settlement agreement.
Yes, so when I say the NDA, typically in a settlement agreement or a COT3 settlement agreement, there will be quite a fundamental provision that the individual keeps the existence of the settlement agreement and the terms and circumstances leading up to it confidential.
Mm,
And that's very valuable to a business. As I
mm,
said, the reputational damage of sexual harassment allegations or a finding is quite high, and businesses are very, very keen to avoid that. If if it's restricted of restricting what can and cannot be disclosed about sexual harassment in a settlement agreement, if that is void, then our view is that it's going to limit and restrict businesses. It's less enticing to settle claims if
mm,
you're paying a sum of money and the individual can still discuss exactly what went on. And yeah, it I can see the logic in it
mm,
because the logic is they don't want it's not they don't want people being gagged and
mm,
speaking about their experiences and discrimination and sexual harassment. I do see the logic in that.
mm,
But on the flip side, they will want to bring an end to the what they're going through. The best way to, excuse me, the best way to achieve that is early settlement. If the settlement agreement doesn't include any confidentiality provisions, then a lot of what will be valuable to a business paying that settlement is gone.
mm. So do you think this will be something that will be revisited, or is it?
No, I don't. I think it will probably happen. It's been a conversation that's been ongoing for a while, and it's just been brought to the forefront here. Um, I'm not sure whether it'll be April 2026 or October. Um, and of course, there's every chance that it does get dropped as things progress. But it's been an important topic of conversation. Um, this government have been keen to include it.
Mm,
I think they see it as key awareness raising and restricting, paying for people's silence essentially. But yeah, I'd be surprised if there's not something to that effect, whether it's watered down or not.
we'll have to wait and see. Yes, absolutely. So I don't feel we have any further questions. Let me just have a quick check of our chat. No more questions. So thank you so much, Tom. Really appreciate that. We feel
Problem.
much more confident on what our obligations are. And I want to thank everybody for attending. We're going to put up a QR code for your feedback in a second. Please do take a second to scan it and provide your feedback because it really is important to us. We do read each one and we tailor all our webinars and events in accordance with the feedback that we receive from you. So please do take a few seconds to scan the code and provide your feedback. I'd like to thank you, Tom, for the great insights you provided. And I think we've all got some good food for thought to take away with us.
Yeah, thank you for having me. And as I say, I'm happy for you to share my details. If anyone's got any follow-up questions, or further discussion, then I'd be happy to chat.
Great. Thank you. I will bring the webinar to a close. Thank you all.
Thank you.